test, test, test. Good evening, YouTubers. I hope you're having a wonderful day. It's Tuesday, 8 p.m., our regularly scheduled live stream. I hope everybody's doing great. I'm down here in Florida, and this is one of our early winters. Today was the first day in a very, very long time that temperature dropped down to around in the 50s, around 55. Tomorrow back to the 70s. So we've got to enjoy our winter as much as we can because it's very, very brief here. We'll probably get that kind of temperature going for the next foreseeable winter. A couple days here, a couple days there. By the way, as you go in, just let me know if the audio and video is working well. I want to make sure that that everything is fine. We've had some problems in the past. I want to make sure that everything we've done is going to be resolved. It was evident within a couple of minutes of uploading video last Friday about the topic, Patreon's banning of Sargon of Akkad off of their platform, that we're going to have a conversation, right? Because I thought this would be a good topic to talk about. I just didn't expect the kind of reaction. Now, I'll be straightforward. I mean, while there was a lot of reactions to my video, if you go through them, all in all, I felt, all comments were constructive, respectful. Some people use colorful language, but otherwise, I think people are passionate and concerned about the topic. I think this is a lot larger than just what's happening here to Sargon. I think this is a part of the entire deplatforming issue. We've spoken about it a number of times on this channel. But I think that because of, obviously, of the popularity of Sargon and the fact that compared to a lot of other people that have been hit with deplatforming is a lot more mainstream, I think that this generated a great deal more passion than maybe other videos. But first of all, I want to thank everybody for posting all your comments for a small channel like mine. I think right now the comments are at 1,500. I think that's excellent. Obviously, I couldn't go through all of them. I went through a lot and I picked out kind of the recurring theme of what you guys want to talk about. What are some of the questions? What are some of the concerns? Some of the suggestions you guys are offering as to what can or cannot be done. And I just wanted to take the opportunity to have a discussion with you and actually just hammer it out. Maybe we can come to some sort of a resolution from the legal side. Again, we're not going to be talking here, at least it doesn't interest me. Politics don't interest me that much, and neither do social politics. So for me, it's all about the law. How does the law looks at it, and what are some of the tools that the legal system provides us to that we can react and fix some of the problems? And that's the only way I'm looking at it. I don't really care on which side of the aisle you're in. Me personally, I'm on neither side of the aisle. I've told you before, even though I'm not political, I'm basically unaffiliated. I don't believe in either party, and I'm just looking at it, trying to look at it in the most rational way, and that's basically how I see this discussion going. So remember, this is, I see that hello AV is good, outstanding. That was Con Clanseth. This is a live stream, right? So it's all about a conversation. So I want you to ask questions. I want to be able to respond. But it's very important that before your comment, you're going to put an @YouTuber Law. You're going to see a little bar coming up once in a while reminding you to put this @YouTuber Law, because on my end, you can't see it on your, but on my end, it shows an orange box which tells me to read or respond to your comment. Otherwise, if you're just typing in questions, I'm going to skip over it. So if you want me to respond, you want me to read it out, just put an @YouTuber Law in front of your comment, and that will give me a hint to do that. So basically what's going to happen right now, I'm going to start the official stream. I'm going to go through maybe 10-15 minutes of just talking about some of the points you guys have raised. Afterwards, I'll open it up and I'll just go through the stream, try to respond to as many questions as possible. Hopefully we'll go through that. 95% of the time I can go through all of those comments. There have been some times where we went on to in excess of 3 hours and I just couldn't speak anymore, and I do apologize it. So let me just go through some of the initial questions here. Again, remember, put @YouTuberLaw. Hold on, let me see live chat. Okay, Rob Wind says, I hope also talk about Milo, who was banned in a day, so almost certainly didn't violate the TOS. As far as I see it, this topic is, again, much larger. It's just Sargon. Sargon is kind of the vehicle in which we're talking about, but it's much larger, and it would definitely also relate to everything with Milo. By the way, I know that there were some comments written before that. You have to understand that YouTube actually starts erasing some of the old comments. So some people went on the stream technically like 2-3 o'clock in the afternoon, and if you don't see it, it's because I've noticed that after a certain amount of time, YouTube just starts removing some of the comments. It's nothing personal. It's just the system deletes them. Brian Gibson, good evening. Looking forward to the conversation. Audio, video, good so far. How you doing, Brian? Rob Wind, video, audio is good. Conclanseth, hello. AV is good. Foolish Dodd, 3 a.m. for me. Really wanted to check your stream. Did you by any chance check out all of the previous things Sargon has done? I'm thinking he was simply walking the thin line. My knowledge of Sargon's background is limited. I've checked him out because I've had, obviously, videos about the topic between the lawsuit between Akilah Hughes and him, and we discussed in the past, and I've always said why I believe that he was in the right when it comes to that lawsuit. So I've had to do some research about both parties in discussing those in the lawsuit and in those videos, but that's pretty limited. I'm not somebody who follows political people, and while I try to look at some of the topics that are trending, so my knowledge is limited about the individuals, and that's frankly how I want to keep it. I go out of my way to try not to follow and listen to a lot of these people, because my interest through the channel is to talk about the legal side of it. So I don't care about whether or not somebody's on the right or on the left, whether or not he's espousing things that might be more radicals than others or more benign than others, whether or not he's pro a particular issue or against one. It really doesn't matter to me at all. The one thing that if you watch my videos, you see that I'm pro is free speech. I think that not only, obviously, in the United States, we are head above any other country when it comes to freedom of speech. Compared to us, no other country has even anything close to freedom of speech. Nonetheless, I think that we can go much further. So if there's something I'm pro, it is that. So to me, it doesn't really matter whether or not I'm advocating for a position held by someone that I may or may not agree with. Cons Clanseth, can Sargon go after the anti-Sargon spammer for tortious interference? That's a good question, and I'm going to reserve it to later on. Please bring it up, because it's actually not part of my list, because I didn't see that being proposed in any of the comments, so I prepared that. But it's not an easy argument to be made here. It could be to the extent to which it's false, and I don't recall right now what is the standard in California, whether or not it's based on falsehood or just, which is, I believe, like in New York, or is it just based on interference, which is like in Texas? And we've seen cases about those subjects in the past. I just don't remember what California law is right now about it. But if you could have identified somebody who then lied about your interaction, specifically targeted and sent that information to your partner, in this case, a platform you're interacting with, that's an interesting argument to have. That might be a potential tortious interference with a contractual relation or a business opportunity or economic interest, depending on the state you're in. I believe here we're talking about California. But I'd have to really read up on California law when it comes to that. And I didn't do that in anticipation, so I don't know. But let's just start the stream so we can get the conversation going here. Excellent, we're back. So I've been reading through all the comments. Reading all the comments is kind of an exaggeration. I couldn't possibly read all of the comments. I read through a great deal of the comments to see what you guys are concerned about, what parts were you opposed to what I was saying, in what parts were you agreeing, when were you asking questions or questioning what I was asserting here. And I think I collected maybe 5 or 6 different points that kind of summarize a lot of the points you guys are making. So what I'm going to try to do in this initial 10-15 minutes is just run through those 5 and 6 points, explain to you why I think that under the current state of the law, that's probably not legally probable way of going after it, a legally advisable way, or there's a probable way that you can win under such a contention. And then I'm going to propose potential solutions here. I'm going to go through that relatively fast. In my video, I said that under the current law, there basically is no real solution to it. That's why I've kind of advocated that people keep talking about it and protesting about it in order to advance changes on the platform. That's true, except that there could be solutions if you're willing to advocate for changes in the law. So what I'm going to propose is maybe 4 potential ways you can advocate for changes that could help the situation. I'm not advocating it because I believe in them or I agree with them. I'm just trying to propose solution to the extent to which you believe that a legal solution is what's needed, not kind of a market-based solution where you're advocating in front of the private platform, but rather a solution that is grounded in law. I'll explain 4 potential solutions that I thought about. I'm sure there's other potential solutions out there, but these are the ones that anyway I thought of. So let me pull up just a couple of my notes here. Okay, so the first most common issue people raised about is terms of service, saying that Sargon never actually violated Patreon's terms of service. As a result, there might be some sort of a breach of contract issue, something that they cannot hide behind Section 230 because this was done outside of the platform. As a result, because it also was not within their terms of service, they could not terminate his relationship with the platform. Now, that's true that there could be a situation under which a breach of contract cannot be overridden by Section 230. For instance, if I go and I buy a video game from you, you cannot then decide not to deliver it. I paid. You have to deliver the product. You fail to deliver, it's going to breach of contract. You cannot say, well, Section 230 says I don't have to provide you with anything because I don't agree with what you're doing off my platform. That's never going to be acceptable. There's going to be a breach of contract. You're going to be liable for my money, potentially even damages, depending on how it goes here. This is different here. This is not exactly the same here. First of all, I've told you many times before, I probably drafted hundreds of different terms of service for different companies. I've never worked for any of the major platforms or for Patreon here, so no conflict here. But these terms of service are always written the same way, which gives the platform any which way to terminate your access to it, your membership, your relationship with them. Why? Because clients always advocate that they may need some way in the future to terminate it. Maybe they want to get out of the business and need to terminate everybody. Happens. I've worked for clients that simply had to make a shift and needed to be able to terminate services quickly and move on to another product. Sometimes they do want to terminate specific individuals, but they never thought about how those individuals might be interfering with their system. It happened many times with people in game system where somebody found new ways to cheat that nobody ever thought about, and they need ways to terminate access, but never having thought about that particular way as being cheating. And so, okay, we don't like this. This is cheating. It's undermining our system. We need to be able to terminate. So the idea that people are terminating you for any reason has always been grounded, and it's in every single terms of service. Now, I looked specifically into Patreon here, and I have to tell you, it's one of the worst terms of service I've ever seen. And it's largely because it's so damn confusing. Now, I'll give them credit in the sense that they are trying to make it easier on people to understand their terms of service. But in the process, it's done really, really badly. And that's because while the business people may have an idea of how they want to simplify it once they give it to the attorneys, we don't know how to simplify things. Our job is to write as much as possible to cover our client's butt. So attorneys are just not good in simplifying and condensing. So we only know how to write more and more and big and longer paragraph and sentences that run on forever. And that's what you have here. You basically have terms of service that start out summarizing everything. And you think that's what it means, except that every single paragraph has a read more. And you click on that and you go into a secondary section where there's more information. But even then you're not getting everything, because even then every subsection has a read more and you go into a third section. And you literally have to go down the rabbit hole, down to the very bottom, to really understand what all those rules are. And that's really why a lot of attorneys don't like that. They're always concerned that they'll be held liable for the summarization when they're trying to help people understand what it is. And people are going to be ignoring the real details, which might be 2-3 levels down here. And it's very, very clear if you start reading it that their terms of service not only reflect what you do on the platform, but also everything you do off the platform. There's lots of discussions about your membership or your association with different groups has nothing to do with what's happening on the platform, but might be happening through your association and behavior off of it. They make mention of, this is the things you're not allowed to do. By the way, this is not all inclusive. If we find that you are finding new and more creative ways to do something bad, we'll go after that. So there's a lot of language that makes it clear that they're not just going to list everything and that's it, or they're not going to say everything you've done on the platform and that's it. They basically are not only providing you guidance through the community guidelines and through the terms of service of what you're permitted to do and what you're not permitted to do, but there is a whole slew of things that they may never have thought of that you might be liable under. So this terms of service, as confusing as it is not different than any other terms of service or any other community guidelines. They can terminate you for any reason, including anything you do offline. This would not succeed under a breach of contract based on the idea that he didn't violate the terms of service, because those terms of service are very broad. Second point, people raise the issue of what if you treat Patreon or any other platform as a utility? Well, then you have to think about what do people mean by it? What does it mean to treat some online platform as a utility and then arguably say that they cannot discriminate against people because it's just a utility? There are utilities like in a home, right? Water, electricity. Why can't you discriminate against people in the provision of those basic utilities? Well, because we have the Fair Housing Act, right? You're not allowed to discriminate against people in housing. So from housing, you stretch it out to a lot of different things associated with housing, including utilities. So to the extent to which certain utilities are associated with your home, and since you're not allowed to discriminate against people in the provision of housing, rentals, and hotels, motel, any place they stay in, kind of public accommodation issue, you're then not allowed to discriminate against them in the provision of basic services that enables their stay in their home. So you have those basic utilities, but this really doesn't fit into any basic utilities. And we can go beyond Patreon to things like YouTube and Facebook and Twitter. None of those really fit under the concept of utility as would water and electricity. Now, there's another concept of utility where this might fit in, which is what the FCC manages or regulates, which is telecommunication. Right? We have a prohibition against discrimination in telecommunication, and that's regulated through the FCC. And we've had those discussions back and forth many, many times within the context of net neutrality. The idea being that depending on whether or not the FCC determines that this particular service is a Title I or a Title II will determine whether or not they can regulate that particular service. The fight over net neutrality was whether or not the very pipelines to the internet should be considered Title II, and then you're not allowed to discriminate access to those very pipelines the same way telephone lines cannot be discriminated against because they're subject to Title II. And there's been a lot of back and forth arguments over it. The problem is right now is that there is a disagreement about the very pipelines that deliver your access to the internet. The current FCC obviously does not believe that the very pipelines into the internet, the access points into the internet, should be subject to Title II, and as a result is refusing to regulate them. Now, the argument then becomes, well, how about services piled on top? If it's not the pipeline, how about the news sites? How about Facebook? How about Patreon? How many services can you pile up on it? It's been my opinion that if you can get to the point where you are willing to regulate the very backbone of the internet subject to Title II, can say that there should be no discrimination in access to their internet, you pretty much are losing the argument on whether or not there can be a prohibition against discrimination in access point to services built on top of the internet. Because first and foremost, you've got to make an argument that that there cannot be discrimination in access point to the internet before you can make the argument that also you cannot then discriminate based on access to Twitter and Facebook, YouTube, and in this case, Patreon. And with the FCC currently not willing to do that, that argument is moot, at least under the current state of the law. You would have to make an argument to your congressman to make a change it. But under the current state of the law, there's absolutely nothing that would say that these services are effectively telecommunication services and not information providing services. As a result, they should be subject to Title II, and there can be no discrimination against them. Next, antitrust. Many people talked about antitrust, and there we have two separate issues here. We have collusion and we have monopoly. Let's go through the idea of collusion here. Collusion is the idea that dominating market powers, a few people within the market, are colluding to control and restrain trade to there. Normally, the way our legal system looks at it is through the pricing mechanism. The predominant way of collusion is for multiple players within an industry to collude as to fix prices or to control prices or to create some sort of a minimum price so that discounting cannot happen here. So that's the kind of collusion that antitrust looks at. You have to understand that collusion in itself is not illegal. Companies collude all the time. Companies can partner together and make decisions together. It's only when the collusion leads to certain restraint on trade that is measured by the court through price mechanism that it becomes illegal. The problem here is that the collusion has to happen between market players to control price access. So if two companies are colluding to keep certain players off their platforms, that's not necessarily collusion unless you can connect it to a pricing impact. Let me give you an example of how, if you could prove something like that, because people have talked about before, that could lead to a claim of collusion, right? So let's say Twitter and Facebook got together, decided that they want to control access to social media. Let's say they even got Google together. Say, you know what? We kind of control different areas of the market. One of us controls video, another one's so-called a social platform, another one's picture, maybe some micro news sites. We'd like to keep that control. Everybody's sitting around a nice room, they're all smoking cigars, and they're saying, you know what? Whenever new players come in, we're going to put pressure, not through our own platform, but on other players to keep them out. And that's how they would have gotten rid of Gap. I don't believe that happened for a second, by the way. But I'm just giving you an example. That kind of collusion would restrain trade because they're colluding to keep a competitor out of the market and in the process controlling prices. You can do it in many other ways. For instance, you can control, if most trade, most of internet takes place through Amazon, you can have collusion to control pricing that Amazon Web Services providing to their own clients in order to keep some clients out of the market. But that's the very basic idea. The problem here that many people allege collusion against market players to try to keep certain people off of their platform. And since that's not a restraint on trade, that's not a competitive position, because these individuals are not competitors of the platforms in no way. Obviously, a lot of the people that were banned are not competitors of the very platform here. There is no argument of collusion here. Now, what I described is known as the market division. The idea that the competitors can collude to divide the market among themselves. There's obviously no price fixing here. So, which is the most common and the one that's easier to prove. And if you can prove price fixing, it's a per se violation, you're in good shape. Market division is very, very difficult to prove. You obviously have to uncover some sort of a conspiracy to have done that. And that's simply not an easy thing to do. Plus, again, you'd have to prove that market players are colluding in order to actually restrain trade, which is not what's happening here. The next argument when it comes to antitrust is monopoly. But just like collusion, monopoly is not illegal. There are many monopolies. Some monopolies grow completely naturally because of the way, let's say there's so many heavy investment in an industry that it's natural that one company can actually build an infrastructure that other companies cannot compete in. So some monopolies are completely natural, other ones are not, just happen through the purchase of and the buyout of different competitors. But in and of itself, a monopoly is not illegal. It's acting in certain ways that is non-competitive that is actually a monopoly. So now you'd have to argue that any of these players are monopolies. The problem with that is that you have to come to an understanding of what the market, that's the biggest challenge. What is the market in which you measure the monopoly? So let's say Patreon. Well, what's the market for Patreon? If you're looking at, let's say, credit card processing, it's the biggest credit card processing company out there, right? It's about 65% of the US market. The next biggest one, I think, is Stripe with about 20%, and then it falls. I think Square is like 2-3%, and it falls down. So it's definitely a dominant player here. It's not a monopoly, but it's dominant. So now you have to say that it's acting in a way that actually restrains competition here. But deplatforming individuals is not a restraint on competition by a monopoly. A monopoly restrains competition by, let's say, going into a market, killing the price, basically selling services below cost in order to drive out competitors and then increasing price. So there are certain behaviors of a monopoly that have an impact on competition, a way of restraining and preventing competitors from coming into the market. But the deplatforming, removing individual, is not a direct violation of competition law. You'd have to make an argument that by banning any one individual, you can then... I actually made a mistake. I was talking about PayPal being the biggest, and then I switched. My apologies here. That PayPal is the biggest credit card processor. So to the extent to which we had bans, I think a few weeks ago, of individuals off of PayPal, and they're continuing, you'd have to make the argument that their behavior is non-competitive. It actually kills competition, restraining competition. And so far, none of that really exists because Gab obviously is not a competitor of PayPal. So now you can say, well, how about this particular case? How about Patreon and their treatment of Sargon or Milo or anybody else? Well, the problem here is, first of all, what is Patreon the dominant player in? They are, at best, a social platform that has certain features that are also existing in other platforms, because they're a very, very basic social platform. They have certain recurring payment that allows people to collect money and they make money off of it, but so does PayPal, so does YouTube, so does Twitch. It's a more focused, feature-based company that is provided elsewhere. So it's very difficult to say that it is a dominant player in an industry. Yes, if you're looking for an independent company that does this one thing, which provides monthly subscription collection services on behalf of content creators. If you narrow down that service to that market, you would say that the dominant player, they're probably a monopoly. But that's not the way the courts look at it. You don't take a company, dissolve it down to its very, very basic essence and say, now that's the market. It's much bigger than that. So that's your problem with monopoly. You'd have to argue that companies such as Patreon is a monopoly, and that's a very hard stretch there. Fifth is the idea that people should eliminate Section 230. We argued, I had that discussion on Friday's video. The problem is that I think there's not a complete understanding of what that section is. So the government originally wanted to pass the Communication and Decency Act, right? This was an act that was negotiated by Republican Congress. That was Newt Gingrich. The Contract with America, I believe it was called. President was Clinton at that time. They wanted to control everything that you can say online. Basically, it was about decency. You can say this, not say this. Basically wanted to establish local rules. So if you say something in New York that is acceptable in New York but is not acceptable in Texas, you can be held liable in Texas for violating some local decency law. That act was all about how the government regulates speech. They tacked onto it Section 230, which was really their saving grace, which was not about government behavior, but about platform behavior, saying that giving immunity to the platform based on what their users say. Eventually, the whole thing goes over to the Supreme Court. The Supreme Court throws the entire Communication Decency Act out, saying it's completely unconstitutional. The government cannot control speech. They kept Section 230 because Section 230 was not about government action. It was about private action. Now, the idea being that a platform is not liable for what you put on it. So if I post a video that is completely copyright infringement, YouTube will not be liable for it because of Section 230. They're not liable for what I do. And that was the biggest issue because there was a big fight back then, a lawsuit that actually necessitated this. It was based on, if you remember the movie Wolf of Wall Street, somebody actually went on to a platform, was called Prodigy. Most of you probably don't remember Prodigy. It was a competitor of what we had that back then, CompuServe, and actually wrote a post saying that the Wolf of Wall Street firm, I forgot what it was called, Stratford or something like that, was a complete scam. 2 years before the FBI closed in and shut them down. The company actually sued, wanting to hold Prodigy liable because they had that kind of a message, a bulletin, a post that made by a third party. And the court says, yeah, Prodigy is liable because they allowed defaming content on their site. 230 was supposed to fix it, saying, well, it's not Prodigy's fault. They cannot be held liable. Go after the individual if he wrote something that was defamatory, but not against the platform. So the idea now is that a lot of time when people are suing these platforms, they're saying, well, Section 230 bars it because the platforms are allowed to remove your content without facing any sort of liability, because that's what Section 230 says they can do. If they allow your content on their site, they're not liable. If they remove it, they're not liable. If they demonetize you, they're not liable. If they change the ranking of your content, they're not liable. So people say, well, let's then remove Section 230 and hold them as publisher. The idea is that we'll go back to what was like before 1996, back to the Prodigy, CompuServe days, treat them the way newspapers are, that they can be held liable. The problem, this will not do anything for you. If right now, Patreon did not have the protection of Section 230, could they not remove Sargon from their platform? Of course they can. Why would they be liable for removing him? There is no law that actually makes that a crime or an impermissible act. There's nothing that says to platforms that they are not permitted to remove. They might lose their protection under Section 230, meaning that if they kept his content on and it's somehow, let's say, defamatory, they'll be liable. but removing it doesn't create liability. So removing Section 230 doesn't do anything for you. You would have to pass laws that make removal of content based on certain objective ideas not permissible, because you have to create something that somehow, let's say, is a crime or is a civil liability, something not permissible. And that just doesn't exist. Removing Section 230 is something platforms don't want, because they want to be able to not face liability for all the content you're providing. But removing it doesn't mean that they're liable when they remove your content, because ultimately you cannot claim that you were damaged by them not allowing you on their platform because of other stuff such as free speech. They are not required to allow you to post on their site. And most of those lawsuits break either in Section 230 or based on the First Amendment free speech. So something else has to happen. We can talk about that as a solution. But removing Section 230 doesn't get you anywhere, because there is no prohibition against removing people off of your site. And the last one, which is really quick, which is just free speech. People have the right to speak. True, against government, these are private platform. You don't have free speech rights against private platform. We talked many times about all the different situations, everything that all the different issues that can come up is a private platform that acts like a public square, suddenly liable as a public square. We talked about it many times. I don't want to bring that issue. That's not a valid argument, because calling something a public square is not in itself an act of actually giving your land, your property over to the federal government and giving it to the public. It's not sufficient. You have to go through a process of actually contributing your property to public purposes, and calling something, and we had lawsuits about it, calling it a public square, a place for free speech. None of that takes away their right as a private platform. I'm just checking to see. Okay, I just want to make sure that the stream is going well here. Okay, so let me just discuss 4 potential solutions here, all dependent on not on today's laws, but what you can do. Again, I'm not advocating that I'm in support of any of them, but I'm trying to explain how you can go about, if you wanted to change the situation, what kind of things would work if you were to advocate them. One of them is the entire argument of the public accommodation and protected class. We've talked about it a bunch of times before. There's a prohibition against discrimination in public accommodation based on certain protected class. That means that you cannot discriminate against people in housing, in rental housing, in hotels, in motels, in restaurants, some retail establishment based on specific classes. And that's usually race, sex, age, nationality, things of that. Very, very structured one. This doesn't work today for 2 reasons. First of all, the internet has not been determined to be a public accommodation the way, let's say, a motel is or a school is or anything like that. So first of all, you'd have to make a determination that access to the internet or to certain services is a public accommodation. That's not a far-fetched idea. There have been arguments about it. So far, it's been very limited, with the idea that to the extent to which you have a retail establishment, but in order to purchase online, you have to purchase physically, you have to go online. There has to be certain the website may be treated as a public accommodation because of its connection. So it might work with respect to Best Buy, but not to Amazon. Stuff like that. But it's not out of the realm of possibility that the internet may be seen as a public accommodation at some point. But you then have to expand your idea of a protected class, because you don't have anything like political affiliation or political speech or social commentary as a protected class. You cannot say that I'm being discriminated against because I'm a Democrat or I'm a Republican, I'm a conservative, I'm a liberal. Those are not protected classes, so you're not getting anywhere. So you'd have to not only make the internet, the websites and certain services to be a public accommodation, you'd have to argue that whatever group you believe is being discriminated against is a protected class. And it's not that easy because basically you're looking, generally when you're adding a protected class, it's not based on something that's just happening today. It's usually based on history. Think about discrimination against women or against different races or against age, something that the courts feel has been happening for a long time and merits protection as a protected class. But nonetheless, that's what you would have to go through. The other one is the concept of net neutrality. We talked about it before. You would have to make the argument that access to the internet is something that would not be permitted. That access to the internet cannot be discriminated against, so that everybody has the rights to it. And then you'd have to build that it goes beyond basic access to the internet, also to certain critical services, one that give you access to different platforms, potentially even financial services online. But that's the argument. You'd have to build based on net neutrality. I don't believe you can get there. You cannot argue that net neutrality is bad, but somehow you should be able to force non-discrimination on YouTube when you're not willing to do it on access to the internet. The two things make absolutely no sense, at least to me, how you could allow discrimination in the entry into the internet, but then non-discrimination based on the services is based on the internet itself. So one of the solutions is to adopt net neutrality. You really couldn't do it through the FCC. You have to go through Congress. They have to pass a law that actually recognize the importance of not only the internet, but also certain critical services built on top of it. Okay, so the third one, and that's only true for specific services online, like PayPal. You might be able to get there by expanding on the what is it called? The Equal Credit Opportunity Act. The idea that certain services like PayPal are regulated through the Equal Credit Opportunity Act, and people cannot be discriminated based on their access to it. Basically, the act forbids discrimination in access to credit. So the argument being that services like PayPal, through credit card processing, especially their dominant position, actually are providing credit to people. I believe that PayPal does provide credit. It's beyond the credit processing. Hard to argue about Patreon because they really are a service that utilize a credit card processor. They're not a credit card processor. They're not really providing credit, but I can see that working with something like a PayPal. Now, you would have to then also expand on the protected class, because equal credit only relates to things like sex, age, national origin, sexual orientation. It doesn't extend to, again, political affiliation or expression. So you'd have to extend the classes protected under the act, but that's not unreasonable. You just have to make that argument to Congress that they need to provide it, because people are not being provided access to credit by some of the largest players in the market, specifically online. And the third one is potentially an antitrust. But I think to get there, you have to go further back. The argument being that it's not as much PayPal monopolizing it, but it's an oligarchy of massive banks that set up rules through Visa and MasterCard and to restrain trade, essentially. That it's the credit card, it's the banks who provide effectively the credit and set the rules that then PayPal and other credit card processors have to enact, that then is restraining trade by not allowing, by effectively killing any sort of competition within the credit card processing. So it's an oligarchy of banks that is preventing any sort of credit access to individuals by killing competition in a credit card processing, by setting rules that nobody can break. So there can never be a competition in credit card processing because the banks set the rules that prevent it. So there can never be a competitor to PayPal that's built based on we're allowing everybody to process it. So you might be able to get, I wouldn't say it's a monopoly, but an oligarchy kind of argument under antitrust that does it. Anyway, those are my basic ideas. And again, an explanation why I think the current law is simply not there today to give you a resolution to some of the issues being presented specifically in this case, but also in any other kind of deplatforming. And those are some of the solution. Anyway, let me know your thought. Let's go to the live stream. Okay. Rudzilla 5332. During the Harvey disaster in Houston, hundreds if not thousands of people were rescued by using Twitter. If they are deplatformed, they have no access to the same platform that our government, Rudzilla, let me see, government uses. Police, fire, or public reps use these platforms to communicate. If the president cannot block people from public square, how can people be unpersoned? Outstanding question. So first of all, I'm just going to get rid of the last part, which is about the president. That was a decision, I believe a wrong decision by just a low-level, talk about a district court judge. It made absolutely no sense whatsoever. It's a solution that never has any logic to it. Under that argument, the idea was that Twitter is absolutely a private company, but when a public official makes a statement, the virtual space beneath that statement become a public, basically a public square, where you cannot basically discriminate or control access. The government cannot do that. That makes absolutely no sense. You basically are taking over private property through the sending out of a single tweet. There's absolutely nowhere in the world in the US market where that can happen, where a government official through a word can take over what is otherwise private property and like that turn it into public land. But that's what the argument is. The government administration is now appealing it. I believe this will fail on appeal because it makes no sense whatsoever, and it doesn't really help us get there. But your argument is completely valid, that things like Twitter, Facebook are so needed, and more than just individuals, the government relies on a lot of those in order to communicate, in a lot of different ways. That may give some coverage for the legislators to sit back if they actually ever did their job and say that there has to be certain access points to individuals. The question is how you get there. So your argument is valid. The question is then, how do you get there? That's where some of my proposals are. Getting rid of Section 230 doesn't do it. You have to create a law. At that point, they would have, let's say, they wanted to make it easy. They could pass a law that says that you cannot discriminate access to those platforms based on what, and then you get into that. See, even when it comes to water and electricity, it doesn't protect everybody. It protects only people of certain categories. So you'd have to argue that this has to be extended beyond it because of the reliance on for safety and rescue and everything else. But you'd have to make that argument. And eventually that will have to make its way through the federal court system and come up probably to the Supreme Court, which then will have to answer the question of whether or not government telling those platforms that they have to allow your speech on, your access to, and your ability to speak through their platform is not a violation of the platform's own free speech, because federal courts have held numerous times that these platforms have a right of free speech the same way as us individuals have a right of free speech. And when they remove or deplatform somebody, that's their expression and they're entitled to do that. So I'm with you on the logic. It's not unreasonable for Congress to do that. I'm not sure if it will pass constitutional muster. And really the worst part of it, I don't think Congress is likely to get anything done. So the chance of it getting done is very small. Nate, what responsibility do these crowdfunding sites have to the patrons of their creators, since we are also contracting them as a service to pay creators? That's interesting, because we spoke about that with respect to YouTube and their seizure of some payment made through super chats, right? So we talked about that, how it's my opinion that they are not permitted to keep the money or send it out to charity. Their only option is to send it back. So that's really it. To the extent to which something like a Patreon, that really is not providing any real service to the individual that are giving money. It's really a conduit from the supporter to the content creator. Their obligation is to send the money, keep their portion that it's agreed upon, and send the money. If they terminate access, their only option is to return the funds back to the original contributor. They cannot keep any of it. That's really the extent of it. But they don't have an obligation to keep somebody on their platform just because you're supporting them. They just can't take your money and keep it for themselves, or the way YouTube did it, which was divert the funds. Oh, there's sorry, I'm gonna jump to the bottom. There's a super chat. The meme of destruction. Cool. Coincidental, California is one of 2 states that lists political ideology as a protected class. Patreon is headquartered in California. Political ideology is not a protected class when it comes to blanket sort of discrimination. So that has been attempted in the past and has not worked. So there's a number of laws that have been used. I forget right now the law that's been called upon a bunch of times, but that argument has not worked. The only effective place where you see it right now, there's definitely New York, California, but only with respect to employment discrimination. So it doesn't apply here. That's why it doesn't work. And in Washington, D.C. So in Washington, D.C., it's the one place, again, you haven't really seen it used in this respect, where political is affiliation. I think it's political affiliation, not political expression, is a protected class. That could be an argument there, but it's very limited. So all 50 states, it's not. So you have it there, but it's really only for employment purposes. So it's your employer not being able to discriminate against you in your job. You know, you support one candidate and he fires you. That's what's being protected, but not generalized sort of against any sort of discrimination out there. Okay, let me see. Sorry. Here, T. Rene. You have to make sure it is spelled the same as the channel name, I think. Yes. YouTuber law. So, guys, if you put an @ and just put the first couple of words, it should pop up above you and you can click on it. If you're not certain whether it's 1 word or 2 words, it should be an option. Just start spelling out the @ Y-O, and then it should come up. .42. How soon until you think the feds eventually start regulating some of these companies' site services as either utility or privately owned public spaces, given their massive influence? The problem here is you've got an ineffective Congress who is not likely to do anything. I think that what you see, and it happened today, and it is Congress calling people in front of them and screaming at them, criticizing them. You're asking Congress to pass something. For that to happen, you need cooperation and compromise. And we've talked about before, that's something that you just don't see nowadays. You don't see compromise. So the likelihood of a major law like this passing is very, very small. You're going to see a lot of criticism. So that's the biggest hurdle. Right now, and I forgot from who, it was one of the junior, I don't know if it was a rep or a senator, circulating around the Internet Bill of Rights. Now, it's much bigger than the Internet Bill of Rights you guys have seen online, in the sense of, you know, one provision about lack of discrimination. It literally includes 10 different things discussing everything from net neutrality to lack of discrimination based on different classes to privacy and your rights to your data and everything else. The idea is there's a whole comprehensive list of issues that need to be dealt with, and Congress needs to start talking about it. And they need to talk about it themselves. And the idea that in the Bill of Rights doesn't assume that every one of those 10s will be accepted, but it wants to start a conversation along those lines. I think if you could get reps and senators to start talking, to realize that compromise is not an evil word, you might get there. and it won't take too long. It's not, these are not simple ideas or simple things. People really have to think about the implication of all of their actions, but you have to have reps and senators willing to actually work with people across the aisle, and that's your biggest hurdle. I think there's a recognition there's a problem here, and it's far beyond the deplatform here. I think there's privacy issues. There's a lot of bad actors online. We need protection over a whole slew of topics, and it's just Congress not doing anything effective, and that's your hurdle. You would get it, I think, very quickly if you just had an effective Congress. Random American. YouTube law is not following one's own TOS a breach of contract. It is, but like I said, all of those terms of service have provision that enable them to terminate you for any reason whatsoever. I've written hundreds of those. It's always in there. And if you start going through the different level within Patreon, it's there as well. There, they can remove you for things you do offsite, and also for things that they have not listed. And they make it very clear. You just have to go through the 3 different levels in their terms of service to get down to the bottom. So I don't believe that it's a breach of contract. It's just, it's in there. It's in there. It's just 3 levels down. Patman Sports. What's the legal definition in California? Legal definition of what? Statute and or common law wise. I guess I'm missing the word. You're asking for a legal definition of something. I just don't know what that is. Just put it back on. Rob Wind. Regarding tortious interference, Patreon's mob declaration was about context, and in context, Sargon didn't do what he was banned for. But that is not... See, the problem here is... And again, I apologize that I didn't review that provision for California. But many times it fails depending how the law is written. In New York, that would fail, for instance. Because you'd have the interference has to cause a breach. And there is no breach between Patreon and Sargon. They're allowed to terminate, so that's permissible termination. So that can never be tortious interference. On the other hand, in some place like Texas, that could lead to a tortious interference case. If you can identify a specific individual, either you identify or through discovery, that caused there to be a break in a relationship, you potentially could there. Again, you're not going to necessarily get... The courts cannot force Patreon to put on Sargon, but that might get you damages from the individuals who actually filed the false flag or whatever, false report. So again, it doesn't solve your problem, but if somebody starts suing them, it might stop people from actually doing more and more of it. So it's a solution, just not to that exact problem. Red Risotto. A V-neck shirt? You're such... Yeah, change shirts today. It's kind of cold. Again, for South Florida, 55, that's freezing. So I'm trying to be more wintry-like. Okay. By the way, guys, depending on some of your words, YouTube is actually blocking a bunch of your comments. I'm just letting you know, if you don't, even if you put it in and YouTube is blocking it, so try to refrain from certain words. Silly Sailor, is the Sargon Aquila lawsuit over? It's nowhere near over. Nothing happened in all these months because basically it was a motion to dismiss, and we were waiting and waiting, and I didn't understand what was going on until I looked into it, and I realized that Trump gave the judge a promotion, and the judge in charge of this case is now in the appeals court, and they have not assigned a new judge to it. So there's still the motion to dismiss, but every time I look, it's the same old judge, and he's not on the case. So I don't know how long before they assign a new judge who will then have to reread everything and come to a decision. But nothing happened. Jay Brown, I missed too much of what you have said. I will have to watch this later. Thank you for covering this. Thank you very much. Nope, hell nope. Mass seems Patreon is going to start hemorrhaging customers. No, they lost me, never got on Twitter, don't use Facebook anymore. I think that they've seen people leave. I mean, I've seen it on myself. You know, people apologize, but they don't want to use Patreon. We saw that, was it a year ago, with when I forgot who was that was removed from it. Was it from the quartering? And that led to a lot of people going to support, right? Forgot what it was called. And that was, with all due respect, that was a complete scam too, that kept people's money and never delivered any of the paid stuff. So it's unfortunate, but within, as an independent company, there is just no competitor. So they will lose, but they're sitting pretty because the only options are for you to use either services like PayPal that has that, but it's not as convenient, not as good, or something like this service is built into YouTube, which is limited only to a large channel, or maybe to Twitch. Nate, as the statement for the cause of these bans are official company statement, can they be held liable for false claims? When they make false claims, the question what it means to make a false claim. If they said he did something he didn't do, they're lying about why they banned him. It's not clear what the violation of the law would be. Am I legally required to say the truth? Well, no. There are certain obligations where a lie may trigger liability, but there is no general requirement in the law that people be truthful, right? If that was the case, Facebook would look a lot different than it is right now. So there is no general obligation here. You're not allowed to defame people. So to the extent to which they are stating specific statements of fact and are causing damages as a result, it could be the basis for defamation here. So that could be, I'm not sure where that would be the case, because again, you would have to point specific statements of fact, and frankly, a lot of their statements are somewhat hazy. They don't really give you details. None of the platforms like to give you details. They don't want, they know the game here. So they give you very, very, very generalized statement without a lot of details because they try to avoid claims of defamation. So arguably, yes, but it has to be very, very specific, and that has to lead to damages. Oh, sorry, for some reason, Siri, the phone is talking to me. Egon T. Ben Shapiro often says that the IT giants should be treated as publishers and not platform, given that they censor content. He's a lawyer also. Has he another interpretation of the law? It's of zero relevance here. That's an argument to be had. And it's not an unreasonable argument. The EU is having those arguments right now, trying to hold platforms liable for content. But this whole issue of whether or not they're a publisher or a platform only is relevant to the extent to which the platforms are liable for our content. So if I put an infringing video on YouTube, it would make YouTube liable for my content. But that's not relevant in this case. It's not relevant for deplatforming because that's removal. And publishers are not liable for not permitting you on the site. You cannot sue the New York Times because they will not publish your letter. You cannot sue CBS for not allowing you access to their news show to say whatever you want to. Their liability is associated with what they permit, not with what they do not permit. So that's an argument to be had, and we can have it, but it's not going to help you in this particular situation. Nope, hell nope. I think the spelling of YouTuber law has to be perfect, caps included. It might be, I don't know. I've never done it on the other side. T. Rene, do you need direct collusion in order to have a trust? Do you need direct collusion? Arguably, no. If you can prove direct collusion, right? A bunch of old guys sitting in a room smoking cigars, planning the destruction of the world. you got something going, right? You got a nice little camera in the corner, or somebody there serving drinks that hears everything, great. But if you can see, most of the time it involves pricing. That's really it. You have to understand that the courts, when they look at antitrust, they look at it from a purpose, from the side of pricing. That if there is pricing irregularities, that impacts the consumer. So if you can show that there is price fixing, you don't then have to show no videotape of them sitting around colluding, because price fixing is, I believe, a violation per se of antitrust. Meaning, if you can show price fixing, you don't have to actually build all the evidence for direct collusion. But assuming you don't have that, then you need to somehow get, yes, you can use indirect kind of argument. Well, for instance, people always say, well, all of these different platforms somehow are deplatforming people around the same time. Isn't that evidence of collusion? That might be suspicion of collusion, but it could just be, and courts have recognized that a lot of times one company sees another, it follows up, and as more and more companies do the same thing, other ones follow suit. They don't want to be basically labeled as somebody that's not going along. So not every collusion is illegal, such as not every monopoly is illegal. So you don't have to, but the question is, you still have to have evidence that shows an illegal activity, mainly ultimately actual interaction, some sort of a relationship, an agreement of some sort. John Penn, they are a banking service company. Who? Patreon? No, they're just a, I mean, okay, so we do have the Fair Credit, which forbids discrimination against provision of credit. So now you're saying that anybody that runs credit card processing through them cannot discriminate. So that would also attach to Amazon, right? Amazon doesn't process its own transaction. It has other companies. So it's not a credit card processing company. Or how about, forget Amazon, because it's not really a good argument here, because Amazon does allow you to use their payment processing on different sites. So let's move on. But let's just assume a different store. Walmart, because they process somebody else's using, I think, First Data, or Best Buy, or anybody else. The fact that you allow payments through your site does not mean that you provide credit facilities, which is that one area that you cannot discriminate against. It's not banking, it's credit. There could be things in banking, other services that people are not permitted to, that there is no prohibition against discrimination. For instance, there are a lot of services that are only open to maybe certain parts of the country and not others, or some services that may not be available to everybody depending on how much money they have. But we're talking about credit, that discrimination on a facility of credit, on anything that is not relevant to whether or not somebody should be provided credit. So obviously, if you're not paying your bills, you will not be given credit. That's permissible discrimination. But obviously, your sex, your race, your residence is not. So I see what you're saying, but it's not everybody that uses banking services is then liable because they discriminate, because the problem is they're not providing credit facilities. Jonathan Giglio, how could customers negotiate their own terms of service? That's a big, big issue, right? So if you go back 15 years when I first started really looking in terms of services, and was getting hired by companies and stuff, that was a big issue. And courts at that time looked at things differently. They said that because these terms of service are contracts of adhesion, they're one-sided, you don't negotiate them, they should be treated differently, and certain provisions should be thrown out. But those days are gone. Courts have since then dismissed those. Those are old cases. They're no longer relevant. And this concept is no longer really relevant, because in retail, for instance, there's no opportunity to negotiate. Now, could you? Arguably, yes. But let me give you an example. If a platform, let's say Facebook, wanted to provide certain services and they wanted something back from you, right? They always want to collect your information, but they priced everything differently. For free, you get everything. You have to give us everything. For $5 a month, you know, we get this much information out of you, and you keep, but we also take away these many services. You know, so you start negotiating what people are getting versus what people are paying for, and what the platform gets. So a platform can do that, but you would have to pass a law that says that, and it's very, very difficult because courts don't want to see interference with the ability of adults and companies negotiating contracts. And a law would have to say that somehow these companies are required to provide you with options. Whenever they have a contract of adhesion, they have to provide multiple versions that provides options so that you can negotiate based on what you're getting and what you're paying, so that if you don't want to provide your information to Facebook, there should be an option that allows you to pay for it and get the services, but not give them as much as they want to because you're paying for it. I can see the platform maybe wanting to do it, but can you see a law being passed that would actually force them to do that? Can that be done? I have not seen a law that actually requires multiple provisions of agreements to force negotiations, because these contract of adhesions are just unfair. You'd have to start with that. Congress saying that these contract of adhesion are fundamentally unfair, and they can only be provided if there are options to get out of those certain kind of provisions that are just inherently unfair. And that would force the platform to provide options. Red Risotto, the biggest problem with law is that they can't keep up with technology. Nobody could foresee the real impact on society, politics, and individuals. The wheel of bureaucracy turns slowly. Completely true. I mean, nobody in their right mind would have known what Section 230 back in 1996, what kind of an impact. In many ways, it was a wonderful impact because that kind of coverage created Web 2.0, right? There is no YouTube, there is no Facebook, there is no Twitter without Section 230. Doesn't mean you can't remove it now, and it still exists. But the impetus for user-generated content was the fact that they knew ahead of time that they can do it without liability. So nobody knows what it is. You can see nothing ever changes. We're dealing with laws from 20, 30 years ago often. Jonathan Giglio, if phone companies are legally obligated to carry phone calls of murderers, why shouldn't other companies' lunch counters be forced to serve the public as well? It's not a bad argument, but that's net neutrality, right? Again, you would have to start with access points. It's easy with lunch counters. It's walking in the door and sitting down, right? There is no levels, right? It's like saying that before you cannot force stores to allow people to eat there without being discriminated against, but you can discriminate against them at their entrance to city. So certain people, let's say women, are not permitted to come into the city, but they're permitted to sit in a lunchroom. That will never work, obviously. That's what we have with net neutrality. You'd have to first protect access to the internet before you can start the argument on it. And again, your biggest hurdle is not that people don't understand this or can have it. It's that you have an ineffectual Congress who never gets anything, right? Where the idea of negotiation and compromise is like a four-letter word that they shy away from, and it's that much easier to just tell the CEO of Google to come in front of them so they can espouse whatever problem they have. It's much easier than sit around and actually negotiate a law and try to make sure that you have bipartisan support to actually pass it. Mike Musk. Let's ask the real question. What about when companies like MasterCard block you? I think that, I think that might be, there might be an issue there. The argument would be, again, that not necessarily MasterCard, but the banks through MasterCard pass rules that then restrict competition in the marketplace. like with PayPal. So it's not PayPal as much as there is no competition to PayPal. There is nobody else that can actually be open to everybody, because it's the banks who through their association with MasterCard and Visa are setting the rules that then make sure that there is no effective competition. That's an argument to be had. Again, it's going to be limited to the payment area. It won't solve this at all, right? Because it cannot be used as a way to force PayPal or Patreon, for that matter, to take on somebody on their platforms. But if you fix that, you might be able to then create competition in the marketplace that then would make sure that people have options when they're kicked off of one financial processing to go into another. Nope, hell nope. Washington, D.C. has anti-political discrimination law. So if a user from D.C. was banned for being far-right, would the tech company be liable, guilty for those laws? We haven't seen it applied in the way you propose. So that will be an interesting argument. It's political. I think it's political membership. It's not a political expression. It's not discrimination based on what you're expressing, but it's discrimination against parties you belong to. So while it's more than anywhere else in the country, I don't believe it necessarily gets you there. But could you do that? Could you say, you know what? It's all the same. Whether or not I'm a member of one party and espouses ideology based on that party, or what I say, it's all the same. So I should be able to file a lawsuit based on political membership because Twitter kicks me off because of what I said that is in line with the political party. So it's an argument you can have. We just haven't seen that. Nobody has gone that far. Again, and it's the District of Columbia, so it's a relatively small thing there. But it's narrowly construed. You'd have to, again, to make the argument, it's not what I'm, even though they're kicking me out from what I'm saying, I deserve protection based on the party because what I said was in line with the party. Somewhat of a stretch. But you somebody may want to try it one day. Our Angel. There were aspects of the CAG versus Crytek lawsuit that didn't get dismissed in the FAC. For example, Squadron 42 being related to SC or twin potential COL, etc. Did the MTD dismiss those too? No. So I seem to have aggravated two different community within the span of 2 days with two different videos. So the Crytek lawsuit, I'm going to do an update on it to explain what it is. Effectively, I'm going to give you a little hint of what's going on here. You have to understand, first of all, I filmed an hour and a half and then I edited it down to 12 minutes. So in the process, I dropped some stuff that in retrospect would have helped clear it up. But basically, when people are looking at the various things that weren't dismissed when the court ruled on the first amended complaint, that's the wrong place to look. The complaint, even as amended from the second one, only has 2 counts: breach of contract and copyright infringement. Everything the court looked at in the first complaint are different factual elements that were questioned by CIG in that. So a lot of things simply are not relevant. Meaning, CIG argues whether or not Roberts Industries should be part of the lawsuit. That's not a claim. They lost that argument. At least it was lost as far as a dismissal. Not as far on its merit, but just as far as the dismissal was concerned. But that's not something that continues. So certain things are not really relevant. And the problem is that what they have lost on now, which is the mandatory license requirement, which is the single most important, because if they can't win on that one provision, it effectively shrinks the entire timeline to an almost where they have a near impossibility of getting anything of substance. And that's where I was going with that, but I dropped off. I cut off a lot of the stuff in order to try to condense and make the story more manageable. But that's inherently the problem. So in my opinion, it's a lost case. I never said they can't amend it or go forward. I just think the case is lost because the single most important provision, it basically then causes the entire timeline. Give you an example here, and I don't want to get too much into details here because I think that people want to focus more on this. But which one we're talking about? Let's the simplest one. The argument being that they were obligated to use Crytek's trademarks in their software. The problem is that if they are permitted to drop you at any time, they're not even required to give you notice of it. They just can stop using it. You have to go to that date as being the end of when they had to use it. Now, Crytek's claim, and I don't have knowledge of true or not, that the first announcement was made at the end of 2016. But it could have been made before that. Mainly, they could have stopped using CryEngine and started using Lumberyard before that and never told Crytek, because it's only about their usage of it. They can drop it in any moment. But let's assume it's somewhere at the end of 2016. That means that the only way to win that argument is for them to, because they can get it out. So once you can drop it, you're not required to use it to put any trademark, that they would have had to have dropped and stopped using and showing the CryEngine trademark in their program back at sometime in 2016 before they switched to Lumberyard. It's where do you go with that argument? I mean, that entire argument was based on the idea that they could say that they were required to keep with it so that they can stretch it on now, so that even though they switched to Lumberyard, they still were required to show the trademark, you see? So the minute they lost that, the argument becomes nonsensical. Potentially there, but nonsensical. And that's what happens also with Squadron 42. Because they lost the entire... Because the minute the court says that they were not required to remain with CryEngine, they could leave at any moment with really no implication, because that's what a license is. That pretty much set the end position of about what's happening with Squadron 42. And the limitation is only when it comes to marketing and sales. So, and the court kind of put it into a footnote about they would have to show that they marketed or sold, effectively, they sold a single game in 2016 prior to their conversion to Lumberyard. So it makes everything very, very difficult. It narrows down the timeline so much, given when everything was released, that it makes it the chance of winning very, very small. So that's my argument there. But I didn't want to get into all of that because I wanted to focus just on the paper. But obviously, people are upset. They want me to talk about it, so I'll publish another video. But that's the argument, that having lost that, they took the timeline that ends as of today and they threw it all the way back to, at most, December 2016. But through discovery, you might be even earlier than that, which makes the entire timeline just crunched up and makes the chance of winning irrelevant. And now it makes it very costly on Crytek, because under the contract, if they lose, they're liable for all attorney fees and costs and everything else. So do you want to? If I'm Crytek, I'm saying, you know what? Let's start negotiating a solution here. Because CIG would want to end it anyway. So CIG might be willing to pay like $100,000 to get rid of this, because they're probably paying their attorney so much. And the chance of winning anything substantial ended. So without getting the timeline fixed, I frankly would try to negotiate a settlement saying, you know what? We're causing you pain. We're willing to drag it out for the next 3 years. It's just going to cost you money. Pay us something to go away. So that's what I would do. Jonathan Giglio. At our Angel, we should go around to municipalities and pass local ordinance making a political affiliation equal religious protection. You could. I mean, you'd have to make those arguments locally that political affiliation is something that should be protected, and you could do it from, state to state. That's not an impossibility. Nigel Rhodes, totally off topic, but have you heard about the Australian lawyer that was working with police to convict her clients in a mob case, and your views on such action? Never heard of it, and completely unethical. In the United States, the attorney would lose their license. I would argue that if it actually happened, something like that under U.S. law, that attorney should go to jail. People may see it as morally correct, but that's the problem. If an attorney, under the guise of actually protecting your secrets, then turns around and undermines you and ends up sending you to jail, I believe that attorney deserves to go to jail himself. He should not be able to cut a deal here because he undermines the entire legal system. So I don't know that particular case, but I find the concept to be abhorrent. Knight's Armament. What would recommend doing if removing Section 30 isn't going to solve the problem? People have tried to set up alternative, but they just keep taken down by activists. Well, I mean, obviously laid out some potential solution, which are legal solution if you're willing to do that. I do believe that, let me be very clear. I believe that the platforms should not be deplatform anybody, short of calls for violence. I would not drop anybody. Done. It's hard for people to argue for things so extremist as terrorist videos and stuff like that. I'm not advocating for that. But short of such recruitment and advocacy for violence, I would say everything should be permitted. The problem is, you're right, that these platforms are moving toward managed communities where they want to set various rules of behavior. So it's definitely, the trend doesn't look like it's moving in that direction. I think that what people are doing is the correct thing. They should be protesting it. They should be talking about it. That ultimately what would motivate it. Maybe by speaking through the completely ineffectual behavior of Congress, maybe it will be effective because of the pressure it places on these platforms. For instance, when the FTC was investigating Microsoft 20 years ago for antitrust violation, nothing really happened at the end of the day. They attempted to break up Microsoft, but nothing really happened. But the constant investigation put Microsoft on edge, so much so that there was internal discussion, because that was by mistake released to the FTC and made public, that Microsoft was saying, should they kill Google? Microsoft could have killed Google in a second by not permitting Google on their Explorer, on their browser, which was the dominant browser in the entire world. There would never have been a Google. But they were so afraid because of what the government was constantly provoking it that it held back. Now you have Google, which would not have existed otherwise. So even though Congress is completely ineffectual, people's protests, people's complaint, your senators hearing about it, talking about it, may eventually lead to enough pressure to make these platforms step back. I know it's not what you want to hear. You want a solution. Other than that, you want a solution, vote for congressmen who actually do their job, who actually want to listen to you and negotiate and work with people across the aisle. There's a lot of the stuff that I'm opposed to, meaning I'm not a fan of a lot of regulations, but I'm willing to hear from somebody because there's a lot of problems we have, and I'd like to think that we can find solutions to them, some legal solutions that can, at the one hand, control some of the problem, but still allow our platforms, our technology to grow. But for that to happen, we need to hear from people from both sides of the aisle, or from people that are not in the aisle at all, people that are completely unaffiliated. For that to happen, DC has to change. The problem is when we keep thinking that if we have all Republican or all Democrat, it's the only way to change. We see that it never works, right? Because when you have one party, they do exactly what their base wants and nothing else. And when you have a broken system where you have two different parties, they do absolutely nothing because they're catering to their base again. So until attitudes change, nothing will change. Let me see. There's a super chat 0212. Thank you so much for the super chat. I've just noticed that super chat won't send anything when I attach names or say my political affiliation. Surely this should be upmost in your mind. No, yes. I don't even know what that means. You mean that it blocks your ability to say your political affiliation? I don't even know how to process that. I don't know. I've never heard of somebody say that. That's obviously problematic, because that's, look, I mean, YouTube puts in a system to catch words. So if they put into their system words that are associated with political affiliation, which in itself is not necessarily harmful or indication of harm, I would consider that to be problematic. The problem is they're legally permitted to do that. That's always the problem here, is that as offensive as that kind of a concept might be, it's not an impermissible act on their behalf. Again, unless you're from DC, and if you're not from DC and you try to do something, again, it's going to be a stretch. You're trying to express yourself, your political affiliation, and you being discriminated against, you're not being provided services because of your expression of a political, then you might have an argument there. That's an interesting argument, just, who has the wherewithal or the desire to get into years of lawsuits over that kind of a small thing. But yeah, that would be an interesting. Howard Dare, thank you so much for the super chat. Thanks for trying to provide service where it's needed. Oh, thank you so much. I appreciate it. Let me go back. I apologize here. Oh, okay, definition. So, okay. Sorry, I'm just searching for what it is. Okay. I apologize if I skipped anybody. I think I found it. It's T. Rene. Did the ruling about Trump Twitter feed crack the door on this? No. It's a low-level, district-level decision. It makes absolutely no sense. It's being appealed right now. I will wait for it to be appealed. If I had to make a guess, I had to put money on something, it's going to get reversed. It makes absolutely no sense. So it's not a crack on anything. It just, to me, it's an illogical decision. The judge knew what he wanted to say, but couldn't find a good reasoning to it. Definitely not one grounded in law. So I think this would not be a difficult thing to actually reverse. Unicorn Spriggles, don't forget to like. Thank you. Asfera, in Washington, D.C., political affiliation is a protected class. You're correct. It is, but it's Washington, D.C., and you'd have to argue discrimination based on political affiliation. Like I said, you might be able to stretch to say that since your speech is in line with your political affiliation, whether it's when they discriminate based on your speech, they're discriminating based on your political affiliation. Nobody has tried that yet in DC. Nope, hell nope. White male, I don't know what that means. Unlucky Eddie. It's life, Jim, but not as we know it. Bob Hambley. Sargon mentioned YouTuber law in a live stream, spoke highly of you, and used your assessment to say he would not be taking legal action. Oh, that's really nice. Thank you so much. T. Rene, what's about public funding? Do not some of these companies get that? So a lot of people mention that, and I have to admit that you guys often know more about what companies get than others. Generally, the rules are that if you don't negotiate certain restrictions when you give it, you cannot come back later and say you should do something else here. So there are no rules that say, well, 10 years ago we actually funded the construction of the internet backbone. As a result, everybody feeding off of it owes us something in return. You would have to have set that in motion when your first investment. So, I haven't seen that done. We see restrictions and rules based on government investment. We saw that obviously during the bailout, there were a lot of rules placed on these companies because of the money that the government was giving to them. But there's always exits, mainly at some point it ends. These companies don't live under the government yoke and under government control forever just because the government helped them. They always have some sort of milestone till... I'm not aware of any money that would still be obligating those companies today. Men's rights at Edinburgh, Scotland, I guess. Could contract law be amended to prohibit arbitrary targeted user removal in TOS? Make any individual user removal be justified by specific TOS violation? That's not a bad idea. That's not a bad idea. See, that's not a regulation on speech as much as it says that it's not a question of arbitrary, that you can pass a law that say that in a contract of adhesion where one party has all the control and can terminate you for any reason whatsoever or no reason at all, they are required to provide you the reason, even if they say we don't have a reason, we just don't want you. Now, that would not stop them from terminating you, but would open the floodgates to you understanding what actually happened, which will make any appeal a lot more successful, because how can you appeal when you don't know what's going on? So that actually is a very good idea. Again, it doesn't allow you to then force somebody to back on, but it will change the dynamics of a lot of things. You could basically say, again, it's going back to the concept that we had like 10, 15 years ago that the courts have passed, the concept that certain provisions might be unconscionable, meaning that they don't have to enforce in a contract during a contract of adhesion, one where everything is forced on you and you have no chance of actually negotiating. So they could go back to that and say, you know what, in a contract of adhesion, such as the online contract, where it's completely one-sided and you can be terminated any time and any certain rules should apply, like full notice. If you are inviting people to come onto your platform and you are transacting with them, there should be a requirement for full transparency when it terminates. We're not telling you you cannot terminate. We're not telling you that, because that's a freedom of speech argument, that if you want to, but you cannot, the idea that you can terminate without any notice, without information, that's unconscionable in this kind of contract. I like that a lot. Again, it doesn't solve it, but I think may change a lot of things when suddenly you are required to provide that information. John Taylor. As a landlord in California, I have to allow political posters up to a certain size protecting my renters' free speech. Can't that reasoning be applied to other venues like Patreon? My understanding is because it's tied to housing. It's not tied to other things. I don't know, but I would guess that if I have a store in a mall, you as a landlord might be able to stop me from expressing my political speech in a poster on my window, because it's not housing. And I think that's connected to the whole concept of fair housing and discrimination, and then tying that to it. The idea is that you cannot discriminate again in housing. Now, I am not aware, I guess definitely not in federal law, political expression is not a protected class, but it could be that under California's housing law, its own state version of the federal law, they include that. My understanding was that political affiliation in California is limited when it comes to discrimination to employment, but it could be that it stretches to housing as well. I'm just not aware of it. Knight's Armament. I wish you could go on a show like Tucker Carlson to explain this to everyone. You obviously know your stuff. I would love to. A lot of smart people out there. I'd love to have a conversation with many of them. Nope, hell nope. Not on Pixel 1. Gotta guess till it's right. Don't know what it means. I have no clue. Sorry. Rob Wind. Could a hypothetical company make a Patreon-like service and make a public square in protecting them from liability? What? Could a hypothetical company make a Patreon-like service and make a public square and protect them from liability? You have to understand that Patreon was never liable. Their desire to remove people has nothing to do with their own liability. That's the whole point. Section 230 of the Communication Decency Act protects them from liability. Their decision is only because they wish not to control community. Maybe because people are complaining, maybe because of the political landscaping. You know, they made their own internal decision there. Maybe because they see other companies controlling the community and they don't want to be left behind, seen as a place that, you know, is allowing rampant speech that is not the kind of speech that they want to promote, not family-friendly kind of stuff. I don't know. But it's not a lack of protection to the platform. The platform are completely. So, yes, you could. Your biggest problem of creating a competitor to Patreon is that a lot of these rules are being pushed, as far as I know, through the banks and through their association, the Visa and MasterCard, to the credit card processors, who would then may not want to serve you. So then you'd say, well, how do you build a Patreon if you potentially are not going to have the credit card processing capability? So that's your problem. You know, could you do it? Yeah, you could probably do it through cryptocurrency or something like that. But to do it through a traditional credit card processing might be difficult. Knights Armaments, are the content creators not considered employees by Patreon, or are they independent contractors? At best, they're independent contractors. The argument is that they're not even that they're just consumers. They are buyers of a service. They're not even independent contractors, so it's a very different kind of rights. They are not working together toward a project. They're not being engaged for any sort of project. They are provided a platform on which they can do some work. So there might be consumers at some level, independent contractors, but definitely not employees. Patman Sports, definition of a public square. Oh, what is a public square? Well, right now is a public square is areas provided by government in which you can, in which you are permitted effectively to speak, in which the government cannot regulate your access or your speech to it. It's something like could be something like a street. They can still restrict based on certain rules that are not speech based, so they can say you're not allowed to stand in the middle of the street because you're blocking traffic, but otherwise they need to be able to provide you access to reasonable place in which to speak. It's provided in parks. They can provide you access there. They can also something that they can provide in any one moment, meaning a government building that is otherwise not a public square whatsoever can then open its doors every Tuesday, allow the public to use its conference room in which to speak, at which point they can't stop you from doing it. Can it be also private land under very strict conditions, like the famous case is of a corporate town where a company owns everything. The company owns the street. They own the mail, the post office. They own everything. If that's the case, if a company takes over duties that is traditionally reserved for government, there it can actually the company at that point will be required to not control speech the way government is not permitted to control speech. The regulations that are imposed on the government will be imposed on the company because it takes on the duties and the role of the government within that space. The problem is that does not apply on social media, because government that's not normally the function of the government to provide social media. So that argument has not worked until now. D33P purple. I don't know if this is true, but I Heard that Alex Jones was banned from Pinterest even though he isn't on there. Isn't that colluding if true? It's funny to be banned off a platform you're not even on. Again, to get to collusion, your difficulty is first you gotta prove it, right? So a lot of these sites can do the same thing because they see everybody else is doing. That's not really collusion. That's just, you know, parallel action. You know, you can do that. It's still in collusion. You still have to come together and make a decision here. So normally you don't have to get to that kind of evidence. You know, the pictures of you in the smoky room and making all those little plans to rule the world. If you can show that, let's say, price was fixed. But if you can't show price fixing, price collusion, you get into other things like division of a market, trying to maintain market access to specific players, stuff like that. Then you have to come with a certain amount of evidence to show that there was a certain level of collusion. And at the end of the day, you have to do that. That collusion is anti-competitive. And keeping an individual off a platform is difficult to say is anti-competitive because it's not a competition to the platform itself. So let's say you could prove that all these platforms colluded to keep Alex Jones off. What's the argument for collusion? Because they colluded in their behavior, but their behavior was not a restraint on trade, which is ultimately what antitrust is. So there's your difficulty. You'd have to make some sort of an argument that Alex Jones is somehow a competitor to the platform because they are, I don't know, like a source of media for traditional media. So they're a conduit through traditional media comes, and he is a threat to them because he was trying to. It becomes that kind of a storyline that is not easy to make. So collusion, again, collusion itself is not illegal, and that's the difficulty here. So I'm not sure collusion is where you would go. Again, I can see through the banking, if you can prove that the banks have set up rules through MasterCard, Visa that are anti-competitive in nature, where they prevent any competitive credit card processors because they will not actually give licensing to anyone that doesn't follow their own rules about behavior, and as such they are restrained on trade among that industry. I can see that happening, but not a straight collusion to keep somebody off, because that's not an anti-trade act. Surdy a lot. How is it not a breach of contract when the CEO specified the terms meant on the Rubin Report interview after Lawrence Southern was removed? Is that not binding in any way? No, it's not. I mean, first of all, the terms of service can be amended at any point. So he could have said it on Tuesday. I can change it on Wednesday. It's not binding, but it's an interpretation of what's there. And if the language is specific, and the language tells you that they can make decisions off of your actions off platform. They tell you that they can do things that are not enumerated in their rules here. So the fact that in a conversation when he speaks, and he might have misspoke at that point, or maybe he was trying to lie, it doesn't make a difference. He said it's only about what happens on the platform. That's interesting, but it's not necessarily a breach. You would have to argue that what he said negated the contractual writing, and the problem is that the writing says that you can't negate it with an oral discussion. So the contract itself says that cannot happen. So you'd have to do something that's not permitted in the contract. So that's a very hard argument to ask a judge to do. T. Rene, is Patreon obligated to either pay out all the remaining fund to Sargon or refund? Yes. They cannot keep it. They cannot divert it the way YouTube did it. They either have to give it to him or they have to issue a refund back to whoever gave the money. Jesse Levitt. What about some amount of fraud or false advertising? As Patreon and the CEO has stated numerous times, offsite actions will never be taken into account. I don't know fraud, but you can argue false advertisement. You know, how far you get with that, I'm not sure here. I haven't really thought of that. But if the company is advocating things that are directly against what they are providing in their contract, and the contract overrule any sort of statements, could you at some point, and it probably is going to be more than one statement, you'd have to show a pattern of that. So a lot of times one is not enough, again, because I can amend those agreements at any moment. So what happens the next day? Where does it go to? But if you can show a pattern of behavior where they're trying to explain this is what it means, then you could argue that there was a false advertising, that people are encouraged to sign contract based on interpretations provided by the company's CEO, and as a result, their actions might be invalid. The problem is that they can then change it again. They can stop their behavior, meaning they can get rid of anybody at any moment. You might be able to get damages because of what you're saying, which might be good enough, but it can't be the basis of forcing them to keep somebody on. Just maybe potentially be the basis for damages. But for that to happen, again, it's not going to be enough that you did, one guy spoke once, even if it's a CEO. You'd have to show a pattern where they're trying to explain the contract to everybody. And you'd have to explain that this guy, that you, for instance, let's say you're a content creator, you would have had to have signed up to Patreon after the date in which the CEO spoke. And then you say, look, I relied on him as the basis for my interpretation of the contract, which was so confusing, I couldn't understand, but I relied on him. And that's why when they dumped me, that was a violation and they owe me damages. Good idea. Okay, I'm just trying to find out where I am. Okay, Knight's Armament. So do you think net neutrality is the best option moving forward? It's not enough. I mean, I support net neutrality, but it's not enough. I think that the way to move forward, and again, I don't think it's the FCC issues. The argument here that the FCC is not your problem. The FCC is allowed to do what it's doing. The FCC is permitted to make a decision about Title I, Title II. I'm not concerned about that. I think that an FCC-style law should be negotiated in Congress that would go beyond what net neutrality says. Net neutrality tries to prevent discrimination in the very pipeline, the access points, to protect both individual access and company access. So it deals in throttling based on Netflix, but also based on your ability to access the internet because of your race, sex, and everything else. So I believe that you need that to be negotiated in Congress, and at the same time to say that given the way our world works today, we need to go beyond the access points to certain fundamental locations. Certain services are effectively accessed to, because it's not just the pipeline. So many of us access the internet directly through the service. That means that, first of all, you have to include not only terrestrial lines, but also mobile lines, but then argue that through certain mobile apps, we then access the internet, even though inherently it's on the backbone of, let's say, a mobile platform. Our access is now directly. It's not the old world where we enter through America Online. If any of you remember America Online, the way it was originally, it was, a bunch of blocks. It provided you, they were the internet, right? Most people didn't even know what the internet was, right? It was a bunch of blocks. Here it's for news, here it's for sports, here's for what your future foretold, here's some stupid games that nobody went to, and there was a block to, the World Wide Web. And most people just stayed in all those blocks. Nobody knew what to do with the World Wide Web. So at that point, the web was just a service, just another click on a button. Not true anymore. Now we reside often completely within mobile app and within mobile services. How many people watch YouTube only on their mobile service through an app? They come in and out of the internet directly into the service and out. They never actually surf to that location. So there is an argument to be made. I'm not telling you it's right or wrong, but there is an argument to be made that access to the internet needs to be preserved for individuals, and so are certain critical services that, while residing on top, represent nodal points, entry points into the internet as well. But that needs to be done through Congress. It cannot be done by complaining to the FCC. I think that the FCC is doing what it's legally permitted to do. It's the fact that Congress has failed to act. It's unfortunately, it comes back to that. That the people that's supposed to pass new laws are just failing to do that. Angela Richter, what about Patreon phoning Tim Pool to talk to him about Sargon's account? I mean, I don't know of that. I didn't see him. So I don't know what that is. So I'll have to, if there's a video on it, I'll have to watch to see, and maybe we can talk about it next week, but I don't know offhand. Meg D, since Sargon is based in Europe, do you think that he may be able to sue from there based on their laws? Yeah. To the extent to which this, and I'm not aware of it because I'm not licensed in the UK or in the EU, but to the extent to which there are certain non-discriminatory laws in the UK or in the EU that might, on the basis of which he can be provided, he might be able to. You have to think about it. If while you sign agreements with those companies locally, there are certain rights that are reserved to you locally. Meaning, if an American signs an agreement with a platform, let's say an online store in the EU, and he has some breach of contract issue, he's going to have to go based on EU laws. Okay, he doesn't have a chance to say that he needs to have rights in the United States. But if he is being certain rights are not providing to him that will be a violation within the United States, he might be able to sue within the United States based on those unique rights, even if they're perfectly legal in the country in which the company is actually located. So it's possible, I'm just not aware of those kind of laws in the UK or the EU where he might be able to, especially like discriminatory one. If there are protection for political expression, political parties, stuff like that, he might be able to say that those companies, specifically also because based on EU laws, all those companies have to have servers within the EU, and all that information has to be stored within the EU, because otherwise it would be a violation of his right of privacy. He might be able to then claim based on local laws. I'm just not aware of that. Meg D, mobile does not seem to fill YouTube law, just an FYI. Oh, I didn't know that. I apologize. I know that it works on the computer. Unlucky Eddie. With Brexit, Megdi, with Brexit underway, there is some doubt that England is in Europe. Not a misstatement. Mike Musk, what about the credit card process if MasterCard and Visa refuse to service you because of your political views? Well, right now, again, we talked about it, that we do have the Fair Credit Act, which prohibits discrimination based on the provision of credit facilities. The problem is you don't have, that's now one of the enumerated classes. You have the regular kind, race, sex, age, stuff like that, national association. You have some unique ones, like if they cannot discriminate you if you're in a class of people that is receiving government aid. So there are unique classes that are unique to the Fair Credit Act, but you don't have the equal credit, but you don't have political affiliation. So again, you would have to ask Congress to actually do that. Red Risotto, Google executive was before Judiciary Committee today and was asked why his granddaughter received X ad on her phone. These old folks have no idea about how much, and they make laws terrifying. If you've watched, I have to watch that one because I only caught the last few minutes, so I reserved it, and I have a long commute tomorrow, so I'm going to be listening to most of that. But if you watch, and I've watched all of the hearings with all the different social media up until now, it is very scary because so many of the people on those committees have no concept of what's going on. They're obviously being fed information by their staff who are much more knowledgeable, but they don't know what's going on, which makes you thankful that they're not negotiating any laws. You know what's worse than me asking them, why aren't you effective in negotiating any laws, is if those people were actually effective and got anything done. Can you imagine some of those people actually passing a law that would make sense, that would not undermine everything that everybody hates or everything that people like? So we've got some problems in Washington. That's for sure. Advert Slaxor. Following Mike's question, Patreon curates its creator to some extent, though it's through its website search feature. It said, what if they could disable that, but not the payment portion? They curate their creators to some extent. Okay, what if they could disable that, but not the payment portion? I understand what. I mean, obviously Patreon could do whatever they want to. Yeah, if you're asking whether or not you could pass a law that would actually say, we're not telling you that you have to keep people on or allow for payment. The problem is, it comes down to free speech, that the law says that everything that they do is free speech. How they curate, what they allow, and arguably what they monetize or don't. So all of those are inherently free speech, so the government cannot step in and actually tell them to do it or not to do it. And so my gut feeling tells me that the Supreme Court would have a problem with that kind of law. Nope, hell nope. Welcome to the internet, a digital land of butthurt and complaining. Kevin Mercurio, do you think Section 230 being so all-encompassing is preventing different cases from being explored in court further to develop more specific precedents? Love the stream. Oh, thank you so much. The problem is that we know the good stuff that Section 230 does. It creates the internet as we know it. We don't know what the impact is to take it off. I don't want to exaggerate to say it's going to destroy anything. We just don't know, right? We never know the impact on it. The problem is that there is no cogent argument to what are we going to provide in its stead. I do believe that a removal of Section 230, which doesn't solve any of the issues in front of us here, would be a complete mistake. The idea that platforms should be held liable for the content they permit means what? That they should allow everything, or they should stop everything? Or what about if they say, you know what? We know the value of independent content creation, but we cannot take the chance that you are breaking the law. As a result, we're going to be like a TV station. We're going to allow all the big networks, all the newspapers, all the TV networks, all the movies, plus the biggest YouTubers there are, to be on our platform. Bar none, that's what it is. And everybody else, you're off, because that's how we control liability. People think that their immediate action will be, of course, we'll allow anybody on the platform, do whatever you want to. Why? Why would that be the action? You're assuming that's the action, but it may not be the action. It might be that they're dumping most people and only keeping the big one. Or maybe they create two tiers, like a free speech tier where they allow everything, but they don't put any sort of SEO behind. They don't do any sort of curation, any sort of search capability. Kind of like Beyond Thunderdome kind of stuff, Mad Max kind of stuff. Put people in the Thunderdome, let's see who survives. And anybody that grows out of it, they may get graduated to the real YouTube and where everything happened. So we just don't know what it is. So I'd like to see an intelligent discussion by Congress to see what they want to replace it with. But just removing it doesn't solve the problems at hand and creates potential massive problem that we don't really know. Mario Kitsumi. Has the Sargon found a new judge yet? No, not as far as I know. Every time I check, it shows the same judge as before. Kisama001. If Patreon can ban someone from their service based on something a person said offsite, what's to stop your local bank, grocer, landlord, or utility provider from doing the same? Well, first of all, because there are direct laws that prohibit discrimination in housing, in financial services, in public accommodations, hotel, restaurants, stuff like that, based on specific classes. So to the extent to which what you are saying is related directly to a protected class, you can be stopped in those specific places based on those specific laws, right? Again, fair housing, credit, bank, which is basically the banking and credit card processors, public accommodations, stuff like that. There is no law today about websites. There are not public accommodations. Again, at least now, nobody has said they're public accommodation. That's your first hurdle. And then nobody says that political affiliation is a protected class. So now, if, let's say somebody goes online, right? And let's say Patreon decides that it's going to kick out somebody who is expressing an opinion about feminism. And then all you would need is a law that says that Patreon is a public accommodation, because they would be covered as a protected class based on their sex, because the speech would be related to their very sex. But to the extent to which you want to be talking about something that is not related to a protected class, like politics or social justice or anything else like that, those are not going to be protected class. So you need to do both. Make either certain websites or every website a protected public accommodation, and make your particular class, which is political or social discussion or association, to be a protected class. Okay, everything got erased. I apologize. Anybody that wrote before half an hour ago, all your stuff is erased. Luis Campuzano, hello, sorry I'm late. How you doing? Squirrel Nut, your thoughts on basing a business on agreements that allow providers to pull the plug for basically any reason, specifically ask about content creators' assumption of that risk. So it's in every single online contract, right? I told you I write it into every single contract, allowing the companies to terminate you for any and all reason. That works for these type of services, right? Where I'm inviting you to do something completely for free. It doesn't impact my transaction with you. If you are paying me for something, I cannot say that I'm not delivering you a service. That you cannot, that'll be unconscionable for me to say I can terminate any point. But I'm allowing you to do something for free, like upload videos, write on a wall, or tweet something. I can terminate your free access at any moment without any ramifications at all. Do I have a problem with that? I don't necessarily like it, but I understand that there is no other way. I've spoken to so many clients about it, and you can see that why they need it. Often are getting into new businesses. They have no idea where they're going. They're putting a lot of money, and they need that flexibility. You're thinking about it from, well, it's YouTube, it's Google and me, it's an established company. They're making a lot of money. It's not an issue, but these are written also by startups. A lot of time they need that flexibility. So I don't necessarily have a problem with it. I like the idea that was raised before, that there needs to be certain clarity, certain transparency in the transaction. So in a contract of adhesion, certain transparency is required, so that they are required to provide information that give the exact reason. And more than that, my opinion, one of the biggest problems here is that not just the reason why, but what brought it. If YouTube on its own discovered that a certain video is a violation of their community guideline, give me all that detailed, including the fact that they discovered independently through the algorithm. I don't have to be told exactly how the algorithm worked. I'm not asking for the secret sauce here. But if it's an individual who is submitting false flags, and you are doing it based on that, I should be able to demand information. Now, in a DMCA type of transaction where somebody is notifying YouTube that my action were a copyright infringement, they are required to provide their name before YouTube takes it down. And yet, and I'm supposed to be able to have access to that information. Yet, when all those false flags are being provided, when I'm not getting any of that information, so I don't know exactly who is accusing me and what kind of information is being passed. So I don't know even how to judge the truth behind what is being said. So transparency is, I think, is key here. Tell me what's happening and tell me if that information is coming from someone, and let me know so that it ends this all these actions based on false information or hidden information where nobody's liable, and it takes no real effort to just flag anybody you disagree with or talks about you or criticizes you. Big Yehuda, I just want to say hi. I'll watch the rerun. How you doing? The J-Vlog, I would love to see YouTube to implement a rating system similar to the movie. We say this is PG-13, 16 plus, just canning people. I agree. My suggestion has always been just to empower the viewers versus the algorithm. YouTube relies, every single platform relies on algorithm that control the stream of what you see and what you don't see and what's being promoted to you. I think it should be changed to allow the viewer to make a decision what they want and they don't want. If I want to have random recommendations by YouTube, fine, I'll enable it. If I want to have access to the complete for anybody and everybody with no restraint, I should be allowed to. If I want to restrain it based on specific topic or specific people, I don't want to see any recommendation, I should be allowed to. Right now, nobody's providing that kind of power back to the viewer. It's all about controlling the stream because they make money by controlling, by showing you what they want to show you. Squirrel Nuts, thoughts on basing your business on... Oh, no. That was just a repeat. Okay, the machine geographical proximity. Don't know what we're talking about. Nope, hella nope. What about the mainstream media running hit pieces and pressuring platform to deplatform Alex Jones after removing a competitor in the news political commentary business? No, that's an interesting argument, whether or not you can go after the media company based on collusion there, that or something like that, and different actions between them. You would have to show that that's the basis for it. It's possible. You know, could Alex Jones, if he had information, I mean, if all you can show is that the New York Times wrote articles saying that Patreon should drop Alex Jones, that's not going to be shown as collusion. If you can show that there's some evidence, maybe some employee at Patreon wants to talk with somebody in the New York Times about, you know, there was some secret meeting and they decided that, there you have a business. See, you can, the courts are not going to, and they've not done that in the past. There have been cases of people tried to go after the media for antitrust based on what they said, and it's been rejected because the courts are afraid to inhibit freedom of the press, freedom of expression, freedom of speech when it comes to media. So they're going to give a lot of leeway for these media companies to say what they want to say, even if that places pressure on all those platforms to then react to it. You would really have to go far beyond that to actually show direct collusion, not just them expressing their opinion. Even if you find that, you know what, they know that if they all do it, eventually there'll be a reaction. The courts don't, they really want to stay away from imposing speech restrictions on media. O212. You can't explain the retort though. Okay, don't know what we're talking about. Talax 001, Internet Bill of Rights. Yeah, I mean, again, the Internet Bill of Rights as provided by one of the congressmen or senators that goes through all the different 10 topics and discusses everything from discrimination, but including privacy and everything else in between. There were 10 different elements. I forgot right now. I think that's a valid base around which a lot of the senators and representatives can actually coalesce around and start discussing. Maybe out of those 10, they can come to an agreement about 3 or 4. That will show progress. But Is there any chance that the Internet Bill of Rights, as you saw on the internet, which only deals with this kind of discrimination, that goes anywhere? I don't think that will go. I think you have to treat the entire symptom here, that we have a lot of issues surrounding what's happening online because our world has moved online years ago and the law just hasn't caught up with it. And I think if Congress approaches in that way and in a bipartisan manner, meaning we've got to get into discussion to solve some of this, if we can only agree on 3 out of the 10, that's progress. I'm all for it. I think that would be great. John Taylor, how effective do you think boycotting or leaving platform is in today's age? It's not effective at all. I think it's a personal statement that you should make, but these platforms are so massive that they're concerned about the impact to the larger community. Meaning, you might want to leave Facebook, but once you realize how many people are on Facebook, Facebook is not concerned about whether you or even, you know, a million people just like you are leaving them, because they are concerned about the billion or so people that are still on it. It's a money machine. It's a private enterprise designed to make money. So I don't believe that it's very effective. If I've spoke about it before, let's say you want to be effective, YouTube is in many ways an easier one. Protesting is not going to get you. Leaving is not going to get you. Creating a union is not going to get you. You want to have an impact on YouTube? Get together in a room, you have the top 20 YouTube content creators, your biggest name with the most followers that generate a good amount of time. Explain to them that they live in a community that they are making money because there's a community that other people support them. Make them actually leading up. If you want a union, have it being led by those individuals. The problem is that those individuals don't care at all about what happens to the rest. They came in, 10 years ago. They're making so much money. They're just happy with the way things run. Once in a while, they'll make a comment, but they're not interested in changing. But if you get some of those large 10, 20 people to take a stand, YouTube then listens. That's what your problem is. Right now, there's nobody on the side of the independent voice, because every media company that's supplying content to YouTube wants a controlled community. Every large content creator is just happy that they can make money even when everybody else suffers. So they'll take whatever is given to them. And the advertising agencies, they want a controlled community. So until something changes, it's not going to come from the advertiser, it's not going to come from the media company. It might come if you can actually convince the large YouTubers to join in. They make an impact on YouTube's bottom line. They change, they speak, they get together and say, look, we need to develop more of a content creator centered and a more of a viewer centered organization that actually listen to what people want to see and empowers them. YouTube can listen to that. O21 is if the Fair Credit Act was working, then this would not be a discussion. It would not be a discussion with reference to things like PayPal. You're right, but then again, you'd have to make political association and expression a class that's going to be protected by the Fair Credit. It's not right now. So you still have to add something to the law to make it applicable to a lot of the people that you're talking about. Justin Quinn, what about the Prodigy and CompuServe cases? Would the repeal of Section 230 revert the law to those precedents, encouraging websites to police content lest they be liable? Well, yes. I mean, basically, if you remove Section 230, it goes back to... People assume it's going to go back to that. It's not a given. Remember, those were early days. Back then, CompuServe policed zero, and they were not liable. Prodigy tried to get a family-friendly community, so they policed. They dropped some people and allowed others. As a result, they were held liable. So the argument is, well, we've dropped 230. Everybody would want to be CompuServe. There'll be free speech for all. No, because we're not some bulletin board from 1996 that so much of what we know today was created by content, not necessarily by by the platforms themselves. And the chances of them allowing everybody to come in when they know how they're making money. Nobody made money. CompuServe made no money off of those posts back then, and Prodigy made no money. They made money off of access fees. That does not exist today. So why would it revert back to those old days? What's more likely to happen, okay, is how do we make money? Well, we make money people watching movies. Let's get the media company, because just like TV, just like a movie, we can pass the rules to control that. How do we else make money? Advertisers. Okay, so we need to make sure that the advertisers are safe, that their rules still exist. So I mean, we have to maybe remove all the small content creators, the independent, those that we can't control, and only allow for the large content creators. It's going to be after the money. So the idea that it's going to revert back to 1996 makes no sense. Because what, YouTube is going to start charging you $20 a month for access? You're going to go back to the access point and then provide free speech? Is that the platform? That has been discredited a long time ago. Nobody has a gateway except things like the Wall Street Journal. Where do people pay for gateways or specific content like Netflix, you know? But the idea that it will then fund... Are you looking for a fundamental change where there's now paid gateways everywhere on the internet? So, I mean... I think that that's not the likely solution there. I think that if you have Section 230 removed, you've got to have a backup for it. But none of that fixes it. You are not... It's not as if Section 230 would then force everybody to keep people on the site. So solve the problem you have, not remove the protection that then creates new problems that you have no way of anticipating. AC, along the lines of protected classes, would declaring anti-social justice a religion help protect people from these deplatforming issues? If you could. I mean, I have no concept of how that would happen, but could you set up a religion? There's some really crazy stuff out there that have been declared religions by the IRS, so it's possible. Asfera. Would stripping a corporation of its human status change free speech laws force them to uphold free speech laws? Okay, wow, that's a big issue, okay? Because free speech extension to corporations was not done by Congress. It was done by the courts interpreting the law to say this is what the Constitution permits or not permit. So government has never been a friend of free speech. Don't kid yourself. When you listen to congressmen, the government has been the enemy of free speech. The only real friend, and it only started out in like the 1920s, has been the Supreme Court. That's where free speech really started, as we know it today, and as we're grown and nursed. And the concept that corporations have rights like individuals, the concept started out during the colonial times, before we had a country. You have to understand that a lot of our states at that point were not colonies, were not states, they were effectively corporations. Corporations explored our countries. Corporations set the basis for towns. They managed things, and they were given rights because of that status. And over time, more and more rights. I mean, until we had the latest case of, now I forgot the name of that case, right? The famous corporate free speech case. Man, that will bother me now. I forgot the name of it. Anyway, so changing that would demand you going to the Supreme Court and reversing, 200 years worth of judicial history, or at least since the 1920s, or let's say 80 years or so, or 90 years of judicial precedents here that has built really on the concept of speech belonging to corporation. So it's a hard job to do that. It's very unlikely. Short of a constitutional amendment, I don't see how that can happen, how you're going to be able to strip, because the courts have only expanded on the rights of corporations as effectively human when it comes to the First Amendment. They've not taken anything away. Asphera would... Oh, no, I just read that. Use BitChute. Isn't Patreon a financial service? I don't see it as such. I see it as just a very mediocre, very simple social platform that has a feature. They're themselves not a financial service. They are not processing anything. It's just a service that allows individuals to post pages and allows the purchase of a service that gives them money through their supporters. They are not the bank. They're not even the credit card processor like a PayPal or First Data or Square. They're just a service providing pay. It's like YouTube allowing you to rent a movie and you pay $9.95 to rent it. It's the same thing. It's just a service being provided. So the fact that the service you're paying for is the ability to transfer money might make them a money transmitter. You could get there maybe through, I'm thinking through as I'm speaking, because it's possible. It gets very, very complicated about a money transmitter and the kind of regulations they face. But but even a money transmitter is not necessarily a provider of credit. So I still don't think that would get you there, because the regulation is about providing credit to the public because of the centrality and the importance of that functionalities in our marketplace, the ability to buy a home, to buy things, to utilize your own funds to negotiate in a marketplace. So I'm not sure that you can still get there even if you make them a money transmitter. Interesting. Henrik Palmegren. Have you noted how much subsidies and tax breaks Silicon Valley companies have received? They're just not private companies. Many are taxpayer funded. Like I said before, I don't know how much they've received. You guys often tell me, and I'm going to assume you guys know more than me. But unless certain things are negotiated at the time money is given, you cannot impose it afterwards. So to the extent to which the government decides, you know what, we think we need internet pipelines through Southern California, doesn't mean, and they negotiate the financing of that, and maybe they took risk and maybe they even lost some money on that functionality, unless they negotiated the idea that everybody accessing it then has to act in a non-discriminatory manner, they are not going to be able to impose it now. So I understand what you're saying, but governments need to negotiate certain terms at the time they're giving the money, not afterwards where they want something out of them. Well, frankly, it's just unfair to the companies themselves. Everybody negotiate agreements. Everything should be upfront. Mike Musk, I think I got a new subscriber from asking you questions, so thank you both for the answer and the new sub. I don't know how that worked, but outstanding. Derek Sinwis. Okay, so it's not practical to make tech giants public utility. So what do we do? How do we get enough people off these platforms? Is there anyone doing what's need to be done at the moment? I think that it goes back to my original suggestion when I was giving you at least 4 different ways how the law could be changed. If you believe that you need a solution that is permanent, that has some legs, that you can rely on, not some executive decision, not some FCC nonsense, but something that we rely on, you got to go back to Congress and you need to change. And it's not easy because often you have to change multiple laws, and some of those changes might have to withstand challenges at the Supreme Court level for unconstitutionality. It's a difficult subject, but I think that's the only way. And I think one way to get there, and we talked about, is the Internet Bill of Rights. Is this concept, we have a lot of issues here. This is one issue. We have a bunch of different issues. As Congress, as a unit, needs to sit around and discuss it, realize that they have to serve us rather than serve political parties, rather than serve donors. They need to serve us as people. They need to sit around, negotiate each one of them, and maybe reach some agreement about some of the big issues that are affecting our lives. I think that's your thing. You can either speak out, have Congress pull people into committees and scream at them, and maybe through pressure these companies will change, or you try to impact them by asking Congress to pass the kind of legislation that can actually have an impact. I know that's not a great solution because Congress doesn't do anything. Unfortunately, I don't see today a law that would actually correct the problem that many of you describe. You'd have to make some changes in order to create the laws that actually will change the very interaction, will change your interaction with companies. Something are easier. I think that some of the ideas proposed, like basically look at every contract of adhesion contract that are being forced on you through social media, through online companies, and say you're allowed to do whatever you want to, but it has to be complete transparency. You have to tell me every time you terminate me or you act under this contract, you have to give me full information about why you're doing it and who's telling you and who's providing the information. I think that would go a lot. But all of that requires, either on a state level or on a federal level, some changes. The J-Vlog, in your opinion, why hasn't YouTube and other platform initiated an ESRB style model? I think that the biggest actor, the reason why they do the things they do is because of advertisers. At the end of the day, they're motivated from where the money comes from. Yes, they're making money by showing advertisement against the content creation, and the content is why people come to them, but they listen to the money. And until the advertisers are pushing it, that won't help. That kind of a model that says, certain videos are, certain are PG, certain are X, that in some way empower us as viewers. It says that we should be able to make choices about what we view. That's not what advertisers want. What advertisers want is, we don't want there to be any of that, because we want to put our message across as many channels, as much content as possible. So until you have somebody advocating for consumer power, for user power, for viewer power, that might come from a company, from the government, or through some advocacy group that has enough power and say, that they might be pushed to it. But right now, there is no big motivator. It's anybody calling them to empower users. So instead, they decide, we'll actually remove any choice and give as much access to advertisers as possible. Rob Wind. Just so you know that I'm going to try to stop soon enough, because even, I don't know, it's 2.5 hours and my throat is gone. It's sore, so I'm going to have to stop, and I apologize if I can't get through everybody. Could a contract that forbids free termination be feasibly created that protects them from liability for speech of users that these big companies could change to if they suddenly went mad? Could a contract that forbid free termination be feasibly created that protects them from liability for speech of users that these companies could change to if they suddenly went mad? It's not that. The question is, could you force them to have no termination absent certain valid reasons? Right now, the legal precedents say you can't do that, because the federal courts say that it's still their freedom of speech. So their ability to negotiate those kind of contract are elemental to the freedom of speech. Now, could the states start saying that in a contract of adhesion, termination absent validity of reason is unconscionable? That's possible, but so far it has not worked, and it's been tried. Jared Taylor in California tried that argument. The state court said okay, but then the appeals court reversed it based on Section 230 and based on free speech. So you could try it, but right now it seemed that federal precedent said that it's not going to be held as constitutionally valid. Squirrel Nuts, thanks for answering my question. I completely agree that full disclosure showing a reason for a punitive action by provider would solve a lot of these problems. Thank you. T. Renee, YouTube Rewind shows how great they control their community. Oh my god, the single worst video I've ever seen. So damn boring. Can never watch the entire thing. Voice of Dissent. The 20 biggest vloggers in the circle Sargon types run in don't mean anything to YouTube. 100,000 times more time and money spent on music and cat videos. I think that you might be right. I think that if you have to get together the biggest people, and I'm not making an analysis of who it is, but yes, I do believe that if you get the largest content creators to speak in a voice, they have an impact, and which is maybe even disproportional to how much money they make to YouTube, because they control so much of the viewership, and YouTube makes money off of the viewership as money flows back. So yes, they get paid because people watch music, and they get paid because people watch cat videos, but there is so much content, so many users being controlled. They have leverage. Can you imagine if those 20 people decide that they want to leave YouTube? It would rock the platforms. I mean, so I'm not saying that they should threaten, but they have an impact. They have direct connection. Trust me, Casey Neistat calls up, he can pick up the phone and speak to somebody. They all have personal representative within YouTube. They have contact information that you and I can't. And they can get some answer. You put 20, 30, 40 of them together around the idea that they should somehow support the very community that feeds them as a whole, not as individually making some video that really doesn't have an impact, but really as a group. I think they can have an impact. And maybe I'm wrong. Maybe that you're right. Maybe that but none of them can have a real impact. The J Vlog, thanks for answering the comment. Thank you. Grant, do user agreements mean anything? Seems like they mean nothing unless they are being used against the user. No, they mean something to the extent to which it describes, let's say, a transaction, right? You're paying to play a video game. They have to provide you that access to. But in those agreements, there's a great deal of flexibility involved in giving you pure access, especially free access to platforms in your usage of them. So they mean a great deal, but they are incredibly broad, which allows them pretty much to do whatever they want to, as long as they're providing you the services. I mean, but they're allowed to terminate or not terminate. So as long as it's expressed in those rules, and those rules are extremely broad. So I can see why they're frustrating to people, because when you write such broad rules, anything goes, but that's the freedom to contract. And it's fundamental to our system that we can contract as adults. We can contract for those kind of broad contracts. You're not required to use YouTube or Facebook or Twitter or Patreon or PayPal. You choose to, and you negotiate those agreements. So, and the courts support that a freedom of contract. So something else has to happen. They mean something, but I do see, the more you guys are talking, and I do see the need for some fundamental changes in the contract of adhesion concept that might empower people that otherwise don't have any say whatsoever in those kind of broad contract. Like, at least provide me back with complete with all the information of why you are terminating me, and what is the basis, and who is submitting the false flags. As you can see, I'm losing my ability to think so very clearly and straight, and I think it's a good time for me to end. I apologize for anybody that I didn't get the comments to. I think I went through a huge portions of them. I think it's pretty. I don't think there's anything else, so I'm going to shut it down. Thank you so much for guys. I hope through a discussion we all learned something. I know that I learned a great deal, some great ideas you guys came up with. And even though there is no direct legal solution today doesn't mean that you're without options. Whether or not it's through your own protest, your own action, you're trying to impact Congress to speak on your behalf and maybe place pressure on those platforms, or maybe change some of the laws that will empower certain changes like the Internet Bill of Rights and some of the elements within those rights. I think there's a lot of challenges, not least of which we have a Congress that has not acted in forever, is not able to work together across the aisles and actually come to any sort of resolution. I think that's the biggest hurdle that we face, but it doesn't mean that we're without options. Doesn't mean we have to like it. Doesn't mean we have to accept what these companies are doing. Doesn't mean we have to stop talking about it. But the law is the law, unfortunately, and it looks from a rational standpoint of that it tries to preserve a system. The law, if nothing else, is very, very conservative, and it wants to preserve the current system as it is, which is, how do I make sure that companies make money? How do I make sure that everything works as it should be? And the result, it doesn't adopt a lot of laws that kind of rock the boat. Anyway, if you have any questions, any concerns, anything you want to discuss, just leave them down below. I'd love to talk to you. I'll see you next time.